Now we're on section 5, and we're blowing by wills. Interpretation and construction. So how do you interpret things within a will? So remember, a will speaks at the testator's death. That means a will has zero effect until the testator dies. That's why you can change a will many times over. You can revoke it, revive it, do it again, amend it however you wish. But once you're dead, the will speaks at the time you're dead, but it's construed in light of the circumstances that they existed at the time the testator executed his will. So if I say, let's say I do my will in 2016, and I give my car to my best friend Adam. Well, the court's going to look at, in order to determine what car he meant, well, what car did Jason own in 2016? So that's what the court's going to look at. So it's going to be construed as the circumstances existed at the time they executed the will. So let's say I don't die until 2087, which is probably going to happen. I'll probably keep living though. But the court's going to look at the circumstances as they existed at the time the will was executed. But the will speaks to the testator's death. All right. First issue is lapse. And lapse and anti-lapse do go together. And you know what? Not only will you see them in wills class, but you'll see it on the MBEs. And you're like, what? I thought that was a wills concept. It's also a real property concept. And it was tested on the last administration, the February administration of the MBEs. So, and they actually used, the wrong answer choices were emption, lapse, exoneration, and abatement. And the right answer was lapse. So don't forget, on the MBEs, you don't have anti-lapse because that's a statutory. Of course, this is California wills. California probate code is statutory. That's why we have anti-lapse. But here's what happens to lapse. Lapse just means fails. And that means the beneficiary dies before the testator. So I give Adam my sports car, and Adam dies a year before I do. Well, because Adam's dead, and he's my friend, because he failed to survive me, which means the beneficiary died before the testator, the gift now falls into the residue, because you cannot give a gift to a dead person. So that's all that lapse is. When the beneficiary fails to survive the testator, so the beneficiary is dead, and you can't give a gift to a dead person, so the gift fails, falls in the residue. That brings us to anti-lapse. Anti-lapse saves the gift. But there are two conditions. Number one, the beneficiary has to be a blood relative, and they have to leave issue. Okay? That's usually what they're going to test you on, the blood relative part. Who's the blood relative? My brother, my sister, my son. I don't have kids. Thank God. My son, my daughter. Sorry, Ryan. I know you do. So if I had a kid, or if I gave it to one of my two brothers, I do have two brothers. That's true. If I gave it to one of them, and let's say I gave it to my little brother Jamie, so I give Jamie my sports car, and Jamie dies, and he has a daughter. So what will happen is anti-lapse will save the gift. So the beneficiary is a blood relative. That's my little brother. And my little brother left issue. He leaves a daughter. So his daughter ends up getting my sports car. Now, in the example that I used previously with my best friend Adam, so I gave Adam my sports car. Adam and I are best friends. If Adam died before me, he's got two sons, Bronson and Brody. Bronson and Brody do not get it because even though Adam left issue, Adam is a beneficiary. He's not a blood relative. He's my friend. So the way the anti-lapse is going to apply is either it's going to be friend or it's going to be brother, sister, or something like that. And that's as far as the examiners go. Brother, sister, or friend. Now, don't forget, a spouse is not a blood relative. Okay, so let's say that I start dating Jessica. And Jessica has a kid. So it's me and Jessica has a kid. And let's say that I give Jessica my sports car. And let's say that she dies before me. And we're married, by the way. We're in love. We get married. We do the whole traditional religious thing. She has a kid. Her kid does not take by anti-lapse because Jessica, even though she left issue, she's not a blood relative. She was my wife. not a blood relative. And the legislature presumes that I wouldn't want her kid to have it because I had no real relationship with the kid. The kid's not mine. It's not my blood relative. And so therefore, anti-lapse does not apply when the spouse is left a gift because the spouse is not a blood relative. Anti-lapse does apply to class gifts, very rarely tested. But if you see like a group of people taking under the will and one of them dies and they leave issue and they're a blood relative. So let's just say I give it to all my cousins or all my brothers and sisters. Say I'm an Irish Catholic and I have 9 brothers and sisters and one of them dies and leaves issues. So I say I leave it all to my brothers and sisters. Anti-lapse will apply in that situation. Now here's a situation where anti-lapse does not apply. Let's say again that I have 9 brothers and sisters and I leave my house to my 9 brothers and sisters. Well, they're all blood relatives and let's say they leave issues. But let's say before I executed my will that I knew that one of my sisters had passed away. So when I say I leave it to all my brothers and sisters, the one that had previously died, that died before I executed my will, anti-lapse does not apply if the beneficiary's death occurred before the testator executed the will and the testator knew it. Well, I've got 9 brothers and sisters. One of them, the sister, like I said, the sister died, so I had 8. And then when I make my will, knowing that I only have 8 brothers and sisters, I'm pretty sure I'd be aware of whether or not one of my family members had died. So if I leave it to all my brothers and sisters, I meant to exclude my dead sister's kid because I would have put a provision in there for the dead sister's kid if I wanted my dead sister's kid to take. So when I said all my brothers and sisters, I meant, the court's going to construe the will, you meant all brothers and sisters that are currently alive at the time you executed the will. So anti-lapse does not apply if the beneficiary's death occurred before the testator executed the will and the testator knew it. Very simple, that makes sense. Okay, moving along. Simultaneous death. That's when the testator is there with, let's say, I'm with my buddy Adam and we're in my sports car and we're driving really fast and we get in an accident and we die simultaneously. That gift that I'd give to Adam, it's actually going to lapse because he failed to survive me. Now, if you cannot prove by clear and convincing evidence which person hung on the longest, took their last breath, if you cannot prove by clear and convincing evidence, then the presumption is that the testator survived the beneficiary, which means if the beneficiary is not a blood relative, then the gift's going to lapse. If it was me and my little brother in my car and we both died and my little brother left issue, then anti-lapse would apply. So with the simultaneous death, if it cannot be established by clear and convincing evidence that a beneficiary named under the will survived the testator, the beneficiary is deemed to have predeceased the testator. In other words, when the testator and the beneficiary die simultaneously, courts presume that the testator survived the beneficiary, so any gift to the beneficiary will lapse. Okay, contracts to make a will, almost never tested, but a contract to make a will or not to revoke a will must be established by clear and convincing evidence. Moving along. Ademption. Ademption is when the gift is gone. And it has to be a specific devise, which we'll get into in a second. So it's when the specific gift is no longer in the testator's estate. The gift is to the beneficiary is deemed or revoked. Now, courts prefer an interpretation that prevents forfeiture or failure of a gift. So, for example, what ademption is going to mean is, so testator executed a valid will. The will said, I give my stock, my specific type, actually that's not even a great example. I give my 1957 Chevy to my buddy Adam. I end up selling that car, probably for drugs or gambling or something, whatever people sell cars for. I end up selling that car because I'm in dire straits. And even though my will says Adam gets that 1957 Chevy, when I die, the gift is no longer in my estate. It's at a pawn shop in Vegas somewhere, go figure. So the specific gift is no longer in the testator's estate. and therefore the gift is now deemed, and Adam doesn't get anything, unfortunately, because the gift's no longer there. The court can't, you can't get water out of a stone, so there's nothing there. So the word deemed means to revoked. Now compare. Ademption is when the gift is no longer in the testator's estate. Lapse is when the beneficiary is no longer alive. So that's the difference between the two. Sometimes people tend to fuse those together, but ademption means the gift. The gift is gone, no longer in the testator's estate. Lapse is the beneficiary is no longer alive. And the reason why you'll know that, it's a good way to remember it, is you have lapse and anti-lapse, and that can only apply to blood relatives. So you know lapse deals with persons, ademption deals with things. Moving along, general devise. Now normally the examiners don't ask you to determine what a general devise or a specific devise is, but a general devise is cold hard cash. That's the best way to do it. It's a general gift. It's a gift that can come payable out of the estate, and just a general asset. It does not give specific property. Like I said, general devise would be cash. Specific devise, that's a specifically identifiable property. Think of it as a unique gift. And what are some types of unique gifts? 57 Chevy, that's about as unique as you get. Gold Rolex watch, pretty unique. A Van Gogh painting, those are all specific devises. And so a specific devise is a gift of specifically identifiable property. It's a distinct gift distinguishable from others in the estate or the will. And to determine whether a gift is a general devise or a specific devise, in case you kind of get confused between the two, it may help to ask whether the testator was primarily thinking of the gift or the beneficiary. Because if you're thinking about the gift, it's going to be a specific devise because it's a unique gift. If you're just thinking about the beneficiary, well, it's probably going to be a general devise. And moving along. Residuary clause. A residuary clause is what remains in the estate after all the gifts are paid out. So it consists of all the property that's not disposed of by will. So let's just say that I die with a net worth. Let's just use my net worth right now. 5 million. There we go. And let's just say all the gifts that I dole out to everybody turns out to be only 3.5 million. Well, we have a lot left over. So we have a little over $1.4 million left over. And that will fall under the residuary clause. And so whoever I have taking on the residuary clause, maybe sometimes I'll have the residuary clause go by intestacy, and you could write that in there. Anything that's left over in the estate can go to this person, can go by intestacy, to go to my little brother, however you want to deal with it. So a residuary clause consists of all property not disposed of in the will, essentially what remains in the testator's estate after all the gifts and expenses have been satisfied. It's what's called the catch-all part of the will. So we have the remainder here, 1.4 million. We catch that, throw it into the residuary, and whoever is the residuary beneficiary takes what's left. It's actually kind of good to be the residuary beneficiary at times. And finally, ambiguities. Ambiguities means it's confusing. We don't know what it, we're confused. What exactly did he mean by my house or my stock or my car? So you can use extrinsic evidence to explain any ambiguities that are on the face of the will. And there you go. That is the whole section of interpretation and construction. And pretty fairly tested, especially the lapse, anti-lapse, really heavily tested. Yeah, and that's actually the most heavily tested right here. And that's it, section 5. We're done.